Good evening, good morning, good afternoon, wherever you are. Welcome to the session of the India ADR Week on Investment Treaty Arbitrations, Massive Claims. My name is Sudhanshu Roy. I am an attorney at Foley Haag in Washington, D.C., and it is my distinguished honor to introduce a very experienced panel who's going to speak about this topic. So on the panel today, we have Baiju Vasani. Baiju Vasani is a senior fellow of the School of SOAS, University of London, and a fellow of the Chartered Institute of Arbitrators, who has recently joined 20 Essex chambers as a barrister. He's also on the arbitrator panels of various arbitral institutions worldwide, including the International Center for ICSID. Baiju holds 4 degrees in law, an LLB, LLM, BCL, and a JD from the King's College London, LSE, University of Oxford, and Northwestern University, respectively. He has spent the past 2 decades serving as an advocate and arbitrator in dozens of high-value international arbitrations. And then we have Dr. Nudrat Piracha. Dr. Piracha is a partner in Samdani and Qureshi, a collaborating firm of Anderson Global in Pakistan. She is an alumna of the London School of Economics, having practical experience as an advocate in the areas of international commercial arbitration and international construction and investment disputes. She's a fellow of the Chartered Institute of Arbitrators, UK. She's also a country reporter for Pakistan for Kluwer Law and Board of International Transitional Arbitration. She has worked with the Infrastructure Project Development Facility, Ministry of Finance, Pakistan, and she has worked with the Infrastructure Project Development Facility of the same ministry on public-private partnerships from June 2009 to January 2010. We also have Carolyn Lamm. Carolyn is a partner at White & Case, and she's in fact the chair of International Arbitration of the Americas at White & Case. She's lead counsel in international arbitrations in ICSID, ICC, and other fora, and arbitration-related litigation in US courts. She is an arbitrator on the ICSID list, first nominated by the United States and then by the government of Uzbekistan. She has served as an arbitrator in ICSID proceedings, SIAC, ICDR, AAA, etc. She's a distinguished faculty chair, White & Case LLM International Arbitration at the University of Miami School of Law. She's the immediate past president, American Bar Endowment, member, advisory council, and previous governing board of the ICCA. She's also on the Council of American Law Institute, counselor for the Restatement 4th of Foreign Relations. She's on the advisory committee for the Restatement of International Commercial and Investment Arbitration. She was also a past president of the DC Bar Association and the American Bar Association, and she has frequently lectured on issues of international arbitration at various universities around the world. We then have Tejas Karia. Tejas is a partner and head of arbitration at Shardul, Amarchand, Mangaldas. He specializes in international commercial arbitration and has an extensive experience in handling a broad range of complex, high-value international and domestic arbitrations across the country. He has represented multinational and Indian corporations before high courts, Supreme Court of India, and various domestic and international commercial tribunals. He also sits as an arbitrator and is well regarded for his contribution to policy formulation across arbitration domain and has a deep understanding of issues to deliver effective solutions for his client. He was involved in the drafting of the 2015 amendments to the Indian Arbitration Act. He's a fellow of the Chartered Institute of Arbitrators, and he's been recognized as a thought leader for arbitration by Who's Who Legal, a leading lawyer in dispute resolution by Asia Law, leading individual by Legal 500, and ranked in Band 2 by Chambers. He was amongst the ALB Asia Super 50 dispute lawyers as well. Forbes India recognized him amongst the top 100 individual lawyers in the legal par list. He's a member of the SIAC Court of Arbitration, on the Governing Council of Indian Law Society. He's also on the ICC Commission on Arbitration and ADR, and the Vice Chairman of Society of Constitutional Law, India. And finally, we have our moderator, Mr. Keval Sheth. Keval is the founder and director of Konverj Zeus. He's a forensic accounting and economic damage expert. He's a chartered accountant with 14 years of post-qualification experience. He's a certified fraud examiner and a valuer of securities and financial assets. Keval is a member of the steering committee of the Young MCIA, the Chartered Institute of Arbitrators, the Institute of Chartered Accountants of India, and also the Association of Certified Fraud Examiners. He acts as an economic damage expert and testifies as an expert witness in various arbitrations under the SIAC, LCIA, AAA, and ICC rules. So with that being said, I hand over the proceedings to Keval. Thank you.
Thank you, Sudhanshu. Thank you so much for this kind introduction. Good evening, good afternoon, and good morning to everyone. And thank you for joining us. And thank you to the panel today that we have with us. We have an excellent panel today. So without much, holding up, let us start, in today's topic, which is investment arbitration, treaty arbitrations, massive claims. Let me begin with, a simple statistic that I have. In 2011, the 10-year rolling average of arbitral awards was just over 50 million USD, which boomed to 125 million USD in 2015, and by 2020 this average rose to over 250 million USD, and this is always northwards as we see it. In the early 2000s, this kind of award would be considered large, but today the sum is quite quaint in that respect. So today, the largest award, as we know, of compensation in the investment treaty arbitration is, USD 40 billion awarded in Hali versus Russia, right? This was the largest of several related claims arising out of the nationalization of UCOs, in which a total of USD 50 billion was awarded. There are now 50 more cases in which the tribunal has awarded compensation of over USD 100 million, including 8 known cases in which a tribunal has awarded more than USD 1 billion. Now, all these, statistics, the numbers and the figures tell us one thing: the amount of claim and the awards are so massive, and they have their, own impacts in, on the claimant as well as the respondent. More on the respondent. So, let's just, quickly dive into the discussions today. I'll first request Ms. Lamm, to have her point of view on 2 things. One, the enforceability and the practicality of the claim, and the second, about the host and the state's ability to pay such massive claims. And then we can go to Mr. Karia on his point of view. Ms. Lamm, if you can, give us your point of view on this.
Yes, and what I'll address, of course, with a comparative analysis of some of the claims, the largest, including UCOs, but only addressing what is public, because I was counsel and am counsel in the UCOs, not in the arbitration, in the enforcement proceeding and set aside proceeding. And as well, there's a second very large claim, the $18 billion claim by Al Qarqani against Aramco in the Kingdom of Saudi Arabia. In that claim in particular, it was 18 billion found on the basis of in our view, and according to the Fifth Circuit, a non-existent arbitral award, and in a non-existent arbitral facility. Basically a fraudulent award, but nonetheless an $18 billion award that the Aramco and the state had to defend against, and have prevailed to date all the way up to the Supreme Court. So it was a seriously flawed award. And fortunately, there are enforcement proceedings or set-aside proceedings where those things can be raised. The second, of course, in the Hully versus, it's Hully veteran and Yukos versus the Russian Federation, that was taken together, a $50 billion award, now worth about $57 billion, challenged in set-aside proceedings in the Dutch courts, because that was the situs. Of course, at the district court level, it was set aside. Then at the first level of the Court of Appeals, it was reinstated. Well, it wasn't really reinstated, but they set aside the set-aside issues. And then it went to the Dutch Supreme Court, which agreed on the ECT issues, but sent back to the Court of Appeals in Amsterdam the question of whether or not there was a lack of candor with the tribunal, and the tribunal was at the outset basically defrauded in terms of who was before it and what evidence was presented. And I recite all of this and all of the enforcement proceedings to highlight the issue that this is very serious for our system of arbitration, for sure, to have awards that are massive, as you've denominated them here, and with some seriously flawed predicates for them. Fortunately, either under the ICSID Convention and the annulment proceedings, or under the New York Convention, or under the UNCITRAL model law on set-aside, in the various national jurisdictions, these flaws can be raised. But the question, I think, for us all to think seriously about is, what does this say for a system of dispute resolution? And what should we be thinking about in terms of the process to assure a better process with better due process submissions or something, so that you don't have a proceeding result in as the catalyst for years of set aside and enforcement proceedings, because it's so fundamentally flawed.
Sure. Thank you, Ms. Lamm. Mr. Karia, if we can have your views on this, please.
Sure. Thanks, Keval. And as we heard, the claims are going on the higher side every time we hear of a new case. There is an upward trend, which is really concerning as far as the amount of the claim is concerned. We have seen number of cases where the claim has gone really high beyond the capacity of the state to even comply with the award. In the recent study done by British Institute of Empirical and Comparative Law and Ellen Overy shows that there is an increase of almost 184% of the award amount, which is a mean amount of US dollar 315 million on an average all the investors have got over a period of time. We have seen that UCOS was referred when we have TCC versus Pakistan. These are the concerns where the large awards are there. It puts a lot of burden on the public finances, especially for the developing countries. If you take example of TCC versus Pakistan, it was a USD 5.9 billion award to a Canadian mining company. And if we talk about the amount, it was almost the same as the GDP, 2% of the GDP of Pakistan, and they had a bailout package from IMF, which is very similar to the same amount. So that creates a huge burden on the state. And again, there is a discrepancy between the amount invested by the investor and the amounts which are awarded in the compensation. What we have seen, for example, in Crystalex versus Venezuela, the investor had spent almost around USD 200 million, and the award was given for 645 million, which is quite high, and the total amount which came to be awarded was 1.2 billion US dollar compensation plus interest. So we have to also see that what is the amount which is invested by the investor and how much they're getting as a result of the award. The other aspect which we have concerning is the regulatory chilling effect on the state, because just the pendency of the investor claims, we have seen that there are a lot of economic activities, social and environmental activities are stalled by the states just because of the apprehension of getting the huge awards against them. So the higher the amount, the chilling effect becomes more severe. There is a reluctance to pay. We have seen in a number of cases that states are either asking for nullification in the state, and the enforceability is an issue. Talking about India, India has created an exception to the New York Convention. And in the case of Vodafone, what we saw is that the Delhi High Court confirmed that only the awards which are arising out of the commercial relationship as per the Indian law would be enforced as far as Indian Arbitration Act is concerned, which incorporates New York Convention in Part 2. So that leaves the investor to enforce the award against Indian assets outside India. In the clean energy case, there were multiple enforcement proceedings filed in USA, UK, Netherlands, Canada, and UAE against India. That leaves also a quite disparity that the state has to go outside their jurisdiction to fight the enforcement proceedings. So these are the real concerns when the amount of the award goes up and there is an upward trend. We have seen that the states have resisted, and in the new model BITs, and if we talk about the other cases where we have seen that the states are putting restrictions by excluding certain types of damages, such as punitive damages. They are prescribing limitation on the compensation that may be awarded. For example, compensation which will not be greater than the loss suffered by the investor, and also requiring that the breach has to have a sufficiently close nexus to the harm, in addition to providing for mitigating factors in calculation of the compensation. So these are the factors which we have to keep it in mind while entertaining the claims. But Keval, I completely agree with you that this upward trend is concerning, and we have to see the ability of the state and enforceability of these awards, because just getting award is not sufficient, because we need to enforce this award also against the state. True. And which should be sustainable for the state as well.
Sure. True. Thank you so much, Mr. Karia.
Can I make one small comment? I absolutely agree. And when you do the comparative analysis of a case like Yukos, where they invested 150 million at the outset, plus hundreds of millions in bribes, and end up with a $57 billion award, that is absolutely incongruous. It's exactly what Tejas is saying.
Sure. So, this leaves us with a point, to ponder upon, how impacted are we leaving the respondent states here, especially when, arguably, I would say, in most cases, these states are developing countries. So, from the impact on its social, economical, and, political scenario of the state. Mr. Vasani, if we can have your views on this, it'll be helpful.
Thank you, Keval. I think I better put on some armor because I'm going to be in a lonely pace on this panel. Nudrat hasn't spoken yet, so but I have to say I fall on the other end of the spectrum to my esteemed panelists. I think, first of all, I would encourage everyone to differentiate between claims and awards. Claims can be whatever the claimant says it is, right? It's unproven, it's simply a claim. We have to remember statistically that only about 30% of claims at ICSID get through to a win on the merits for the investor. Of those, the amount claimed is, again, about 30% is awarded in damages. So let's not use claims, please, as our barometer for any concerning trend, because the claims can be whatever the claims are. It's the amounts awarded that we should, from which we should be looking at trends. So I think that's one point. Second point, what I didn't hear from my friends, and I think is very important, is what is the value of the actual value of the asset taken? So in other words, 2 billion might be a lot, but 2 billion is actually a very good deal for the state if what they took was worth 6 billion. So I think unless we establish what is the actual worth of the asset taken for which the amount was awarded, I think we're somewhat saying, well, 2 billion sounds like a big number, but actually what has the state got in return? And if it's got a big amount, for example, my understanding of the UCOS case was that the actual asset was worth a lot more. At least the tribunal found it was worth a lot more than 57 billion because they put some discount onto that for various things that the claimants did. So actually, if one accepts that the Russian state took the assets and nationalized them unlawfully, then actually they got assets worth a lot more had they bought them for less, had they bought them in the open market. I also think we have to establish between those cases where you're looking at regulation in the sense of for climate change, for health, where the investor is, let's say, an unfortunate bystander to something that is a legitimate policy of the state, versus those cases where you have outright and blatant nationalization for policy reasons. So they just talked about Venezuela, but Venezuela was a left-wing government that decided without any lawful excuse to simply expropriate swathes of the domestic economy. So I have very little sympathy for a state that does that and then says, well, now I have to pay 2 billion. Well, you should have thought about that before you breached international law. So that's my first pillar, Keval, that I think we need to put a flag in the sand. The second thing I think is, well, a lot of these cases have or would have had underlying contracts in any event, right? A concession agreement or contracts with the state. For me, the damages would have been the same or similar had this been a contract dispute. So I don't think anything per se, the fact that this is a treaty violation as opposed to a contract violation, one still would have done a DCF, one still would have valued the asset had one found a breach of the contract. So I think, again, one needs to say, well, pointing the finger at treaties and saying, well, contract is the answer, that wouldn't have changed for me the damages assessment necessarily. Another point that I think we need to bear in mind is that, you know, these are for breaches of international law. Now, for the most part, they would also be breaches of customary international law, so not necessarily just the lex specialis of the BIT or the multilateral treaty. And we have customary international law that has then been, in some sense, embodied in bilateral investment treaties to act as a deterrent and a guide to nation states to act in accordance with international law. So in a way, the fact that we have these awards, you know, a chilling effect can also be a positive in the sense that it makes a state think, is this something I'm doing in accordance with international law? And if it's not, then I think we as a global system don't want them to undertake that particular act. So what would we have if we didn't have this system? Well, you would either have no investment at all, right? Because you don't have any treaties. Okay, I can't be sued for these seemingly large amounts. But then would people really invest in the country? Possibly. How would they do it? Definitely on different terms, right? So if I've got an investment where I don't have investor state protection, maybe I've got political risk insurance that would also add a big premium to my investment, which would then reflect in the deal I would strike and whether I would go into a particular country at all. we also have to remember that the state has years and certainly months and months to negotiate, to compromise, to talk to the investor, to change course. Because what we are talking about here is not the threat of a claim, but the actual claim where it founds that the state breached the treaty, right? And in that instance, the state had the opportunity to turn around and act according to international law. Finally, I would say that, you know, these treaties, I agree that the older treaties have been subject to some misinterpretation, some abuse, some rather loose interpretation. But again, these treaties are between states. The investors are simply third-party beneficiaries of a state-to-state system. And if states want to change it, rather than, you know, sort of these general attacks on the sizes of claims, for example, they could, but often they don't, go for things like transparency or to renegotiate the treaties, to tighten them and to make them into a system of law that both attracts investment, but at the same time avoids any unjust or unfair awards. And here I would agree with my colleagues that I think if an award is unjust or unfair compared to the act, compared to the value, there I would think that we absolutely want to make sure that the system is one that works for everybody.
Sure. Thank you. Dr. Piracha, please.
Thank you, Keval. First of all, it is a pleasure to be amongst this distinguished panel, and all of you who are attending the India ADR week. Now, as far as my views are, having served for the states, the investors, and member of the Nullman Committee, I would want to bring a different or a unique perspective to the discussion, which I think is something that is often missed in the discussions. First of all, I do think every case has to be seen on its own merits. And usually the discussion that we find, it is distinguishing between the interest of the state and the investor, or it is distinguishing between how the developed states are treated versus the underdeveloped states when it comes to quantification. The perspective I want to bring to the table is that we need to distinguish between the government and the state in these discussions. I think a fundamental unsaid presumption in international law and these investment disputes is that the government is working for the benefit of the state. Developing countries, that is not the case. Many of these governments are not working to the benefit of the people. These countries sometimes have successive corrupt regimes, right? And all the cases that Pakistan has had so far in ICSID, it is public knowledge that all of them had a component where corruption was alleged as a defense. In all these cases, Pakistan ended up settling, except the exception is agility, where payment was made to Pakistan rather than the other way around in the settlement. In all other cases, Pakistan settled and it paid monies to the investor. Even in the Tatian case, we have had a settlement. Now, the irony is from the Pakistan's point of view, the award was too much. And from the investor's point of view, the award was too little. The assets were way more precious than the award that was rendered. Now, if you look at one aspect that was mentioned by my colleague earlier, of course, if this award was ever to be enforced, given that the IMF bailout that we negotiated was around $6 billion and this award is nearly $6 billion, the impact would be significant for a state like Pakistan. But if you look at the other side that is not discussed, the Tatian or the Reko-Dik mines, as we call them, it is the 4th largest gold reserve in Pakistan, in the world, right? In Pakistan, there have been debates about the interests of the federal, the interests of the province of Balochistan, where these mines are located. And this project has been locked up because of the interest of stakeholders who were looking at their own interests. Now, this project alone, if it was properly developed, it can pay off all the loans that Pakistan has. Yet this project had been locked up. I would not go to the extent of saying that the end justifies the means. But this project, had it been unlocked, had there not been this threat of a pending $6 billion award against Pakistan, if this project was ever constructed, and now there is a settlement to construct this project, it would result in benefits not only for the people of Balochistan. The stakeholders are at the moment the federal, the province of Balochistan. Everyone is going to benefit from this project, which would not have been unlocked otherwise. So we need to keep in mind that these awards, they sometimes end up benefiting the state, who should, I think, be the beneficiary of the system. When you look at the interests of the government, it needs to be aligned with the government, with the interests of the state. And in many of these developing countries, I feel that the interests of the government is not aligned with that of the state. So if we look at the political ramifications of this award, Pakistan has decided to opt out of the bilateral investment treaties. But is it eventually going to serve the benefits of the state, maybe a particular government? But in the long run, I think international law, what it does is it gives you standards that states need to live up to. And these standards help these states, even the developing states, to grow into something better and to develop in the long run. So while we are looking at the interests of the government in taking measures which are very short-sighted, my question would be, using these awards, which some of them I would not agree with, but using these awards, should we undermine the system as a whole to benefit the government at the detriment of the state? So I would leave you with that question.
Sure. Thank you. Thank you so much. We can, clearly see the two different schools of thoughts, right? And that is what it makes this topic very interesting. So moving on, there's a different, another line of thought, which says that in many of the cases, the arbitral jurisprudence on the compensation has been inconsistent, arguably so, especially in terms of, the circumstances which it, is appropriate to calculate the compensation based on the investment's expected future income. The second, the quality of evidence needed to back up the projections that underpin the future income calculations of compensation, like the DCF method. And the third, the way the tribunal accounts, for risk to an investment's projected income stream across the different, entire life cycle. So, I would, quickly go to Ms. Lamm for her views on this.
Yes, I know there have been some criticisms as a result of alleged inconsistencies, but exactly as Dr. Piracha said, each case is decided on its own. I don't know that we can look to the investment cases to discern an absolute cookie cutter approach to the quantification of harm. It is the exercise of the tribunal's discretion in light of the various factors, and in each instance, you have different arguments by the parties as to the nature of the harm, different arguments as to the applicable law and what it provides for, different experts submitted and proof and evidence of the damage or the harm imposed. And given that kind of a constellation within which a tribunal is making a decision, it's nearly impossible to say anything other than the case must be decided on its own merits. And I think the most important elements really must be causation. And many times I find tribunals overlook the nexus between the alleged wrong and the alleged harm, and then the numerical quantification of what that is. But it's a very important aspect. And I think that you can't approach any of this by saying, oh, it's entirely the international standard, because once you get beyond the treaty interpretation, you do have to look at economics, you do have to look at accounting, and you have to look at some aspects of national law that hopefully do meet the international standard, but you can't ignore, just because it's an international treaty case, the host state law. So it's a constellation of things that should inform any quantification. And Baiju pointed out at the outset about the value of the asset taken. Well, many times there is a great disparity in terms of views as to the value of the asset taken, if anyone admits a taking. And I would just note in the Yukos case that he mentioned, it was pursuant to a privatization decree that provided if there was any collusion or corruption, it was void ab initio. So in a national law situation like that, why should people who invested the minimum come out with 57 billion? It's breathtaking. Anyway, my views.
Sure. Thank you so much. Although these debates are technical, there can be hundreds of millions of dollars at stake in tribunal's choice of one approach over another. For example, the choice between the different valuation methods in Bear Creek versus Peru made the difference between the USD 500 million in compensation claimed by the investor and USD 18 million as compensation awarded by the tribunal. In Tatian Copper versus Pakistan, the tribunal confronted essentially the same question as to the appropriate valuation technique and sided with the investor, resulting in a 4 billion plus interest awarded, the mentioned above. From a legal perspective, can this be more streamlined and given the right perspective? Mr. Karia, if you can, enlighten us with that, please.
Yes, definitely. Because what I feel is that we heard our colleagues saying that every case has to be dealt with on its own facts. But the consistency helps, because consistency brings certainty and also brings in its value to determine the case with the standard which there would be some predictability. And what helps is that there are various moving parts in the whole process of investment treaty arbitration, because I would think that it would be different than pure commercial arbitration to some extent, because there is a state involved and the considerations are quite different. So when it comes to the principles of quantification, we need to see that which method should be adopted, because as you rightly pointed out, depending on the method which is adopted, the outcome can be quite different. Whether to have the income-based approach or the market-based approach, you have the asset-based approach also. So depending on the facts, the tribunal has to decide. But if the facts are similar, and in most of the cases we see that there is a similarity of the facts, then this consistency across the different tribunals would really help in determining the outcome. Because what would happen is that then the states would not be able to judge what would be the outcome unless and until they know what is the the methodology which will be adopted by the tribunal. There is another view which is possible, is that the inconsistency is the inherent feature of investment arbitration, because the tribunal has duty to decide in an accurate, sincere and transparent manner. But the majority view is that there should be consistency in terms of the interpretation, in terms of adaptability of various methodologies, and especially the quantification of the damages or the compensation which can be given. Even in fact, UN working group also is looking into this whole aspect of consistency. And what we have seen is that there are different aspects which the tribunals have to look into. One is the valuation date, as is very important, because what would be the determinative factor is that what is the date on which the valuation is being done, or whether the damages for an unlawful expropriation should be calculated according to the FMV or the reparation standards, because again, the outcome could be drastically different. The varied approaches on question of causation, as we heard, also is very important, because whether a supervening event should be understood as a breaking a chain of causation between the host state's breach of investment treaty and a loss suffered by the investor is a very big question, which every tribunal has to answer. Again, the interest part is also very important, because what kind of interest is calculated? Is it compound? Is it simple? Also the burden of proof, because every time you apply different burden of proof in assessing different elements of the damages claim also plays a very important aspect. So there are a lot of challenges which every tribunal faces. But at the end of the day, we need to see that if we can develop some consistency, again, it's an international law, and the tribunals have to decide taking into consideration various factors. But it would really help if we have some consistent methods and a soft law which can be adopted internationally, which would then be a guiding factor for determining the damages which can be awarded by the tribunals.
Sure. Thank you, Mr. Karia. Another problem in recent arbitral practice is, tribunals' growing willingness, to grant large amounts of, compensation for state interference with planned investments that were never actually built. In such cases, there case, be a vast discrepancy between the amount of money actually invested by the investor and the amount obtained in the compensation. In Titan versus Copper again, versus Pakistan, an investor was awarded USD, 5 billion, 4 billion plus interest for Pakistan's failure to grant the necessary approvals for the investor to build and operate a mine, even though the mine was never built. The tribunal, based this compensation on its estimation of the income the investment would have, earned over its 50-year operating cycle if it had been built. This award is large, almost as large as International Monetary Fund's bailout already agreed earlier, with the intention of saving the Pakistani economy from collapse. The possibility of large payouts of compensation, particularly for interference of, with planned investments that are never actually built, also risk the encouraging serious corruption. This is, because the possibility of large awards of compensation increases the potential payoffs of an unscrupulous investor to enter into corrupt investment contracts with the host state, even if the investor never intends to perform the contract. What's your view on the valuation of claims, and what is your take as an arbitrator? If we can, go to Dr. Piracha first.
Thank you for that question. I think in international law, there do exist standards and there are checks and balances. If the tribunals stay loyal to them, we would not be seeing the mess that we see in some of these cases. And Tatian case, I think, is exemplary in going against those established norms. In calculation of damages, it has been the practice of exit tribunals that speculative damages should not be awarded. It has been the practice of exit tribunals that the investments which have not left the boardroom and for which there was no track record of profitability for that particular project, a large number of exit tribunals have refused to use the DCF method in those cases. And Tatian case, I think, is exceptional on two accounts. First, it was the very first time that the tribunal has used what they call the modern DCF methodology, which has never been used by an exit tribunal for calculation of damages. And in that, what they did was they have discounted the risks. Those risks a bystander would think are the exact thing which were speculative. If the tribunals were able to discount the speculation in the damages that are being claimed, we are looking at a menace that we will not be able to control. In that case in particular, you're quite right. The total investment of the investor was 200 million. The project never moved beyond the feasibility study, and they walked away with an award of $6 billion nearly. Had it been the principles that have been adopted by exit tribunals in the past, we would not have the same results. Similarly, the interpretation that was placed on some of the writings of the jurists, the jurists have since then expressed their view that the tribunal's findings was not in accordance with what they had actually written. So I think just by staying loyal to the principles that are already out there and what international law standards are there, the tribunals can avoid a lot of difficulties that they have got themselves into.
Sure. Mr. Vasani, as an arbitrator, what would be your take on this?
I crossed swords with two panelists, and now I'll cross swords with Nudrat. I think one has to start by differentiating between what is the asset on which you are conducting a DCF. If it is a business like a hotel or a factory or a new idea, I'm coming with a new IP, I can understand that you want history of operations, you want some proof of operability, you want some proof that this particular person can run that operation, and that in and of itself leads to speculation which may make DCF inappropriate. Where DCF has been applied, and here is where I disagree with Nudrat, I think there is a pathway which has been shown by exit tribunals, where one is applying DCF on resources or proven regulation. In other words, you've got a guaranteed off-taker market by the state, right? The state buys electricity or whatever so it's a guaranteed contract. But let's talk about resources. Where you have resources, and that is oil, gas, metals and minerals, particularly gold, because gold has a guaranteed market, right? You can sell gold to UBS in Switzerland, 100% guaranteed, they buy it. Other metals, less so, but still you're talking about resources in the ground. Now, what that then depends on is a very different body for speculation versus the factory or the business or the IP that I've talked about. When you've got resources in the ground, what you're trying to show is how much can you prove that they exist, one, and two, that you can get them out and make money on them. Now, for the most part, you don't actually have to start necessarily drilling. It helps, right? It helps that you've got a feasibility study. It helps that you've done seismic reports. It helps that you've done exploratory boreholes. It helps that you have actually in your pilot project sold some of the resources. But as one goes across that spectrum in resources, you do get to a point where it is relatively clear that a DCF would be appropriate in order to value that particular asset. And I would also say on the appropriateness of DCF for resources, that is how, even on exploration properties, right, where the state believes, usually through things that were done in the 60s and 70s, for example, in Soviet times or in previous governments, those are also valued as between purchasers as by DCF. So I don't think one can say to tribunals, how are you applying DCF to a field full of oil, right? When that's exactly how those things are. So in other words, if I wasn't claiming for damages for that field, but I was buying it from the state, we would do a DCF. That's how we would value the field. So I'm not sure how you can go to the tribunal and say DCF is inappropriate for that type of project. Now, there are even cases where resources are so inherently speculative that DCF is inappropriate, but I really do think that one has to differentiate how is it done in practice. So if I was going to buy that Tethyan mine, we would use a DCF just to buy it. And so I don't know why it's then inappropriate to do damages by it. That's my first point. My second point, this has been said a few times, the idea that one has to marry the amount spent and the amount claimed. Now, I'm not saying one doesn't have to look at that. There is always you look at the delta, and maybe your skepticism can be put into a prism using that. But I don't think that should be or could be a hard and fast rule as to the appropriateness of damages. For example, again, I'll go to resources in oil and gas. If the government gives me a field to explore and I get very lucky and I spend 10 million drilling a hole and I strike the biggest oil field the world has ever seen, and I've spent $1 million, that field is worth $1 billion. So you can't tell me, well, I'm sorry, you only spent $1 million. No, but I found an oil field worth $1 billion. So if there is a plausible explanation to explain the delta between the amount spent and the amount claimed, then I think that there is nothing wrong with the amount spent versus amount claimed. And particularly in resources, which is a speculative venture in the sense of people are most likely going to lose their money. People who go and drill for oil and for gold lose money every day because they drill and it's dry. They drill, there's no gold, or the gold is so far in the ground or so that the grade is not good enough to get it out the ground. They lose their money all the time. But when they strike it rich. They call it pay dirt, striking it rich, because there's an element of gambling in the concept. And that means that one doesn't necessarily spend $1 billion to get 1.2 billion. If they wanted 5% return, they'd stick their money in the bank, right? If they're looking for an IRR of multiples to do an FDI in a very difficult venture in a very difficult country. And so I don't see this concept necessarily being a hard and fast rule.
Sure. This has been a very interesting discussion come debate, I would say, in some sense. And, as we come to the last section, where, if I were to ask what can be done as a change, at least from a point of view of awarding the righteous amount of claim as compensation, from a quantification point of view, I would, start to think, can there be a revisit on, how to claim, how the claim needs to be calculated, or even how a claim can be capped, if it can be. Can a tribunal consider whether the host state has obtained any benefit from allowing the investment to proceed and then, breaching its obligations under the investment treaty? If yes, the compensation would be capped, at whichever amount is lower between the host state's gain and the investor's expenditure in making the investment. And if no, then no compensation would be owed. So, some lines of thoughts there, if we can, close the topic with Ms. Lamm first, and then Dr. Piracha. Sorry,
it's a very important point. I'm sorry. The primary source of the applicable law is the investment treaty. In the absence of any provision in the treaty, of course, tribunals apply customary international law, general principles of law, but only to the extent that the treaty is silent. So if you don't have a provision, you're in Chorzów factory where you're wiping out all the consequences of the illegal act, and tribunals have incredible discretion. States have the power to set valuation standards that they would like to have the tribunals apply. And they can do that by negotiating or renegotiating their treaties or agreeing to interpretive statements. And at times we see that the Vienna Convention, of course, allows that. And you could have an interpreted provision statement further defining. And in fact, I note that India's model bit from 2015 in Article 26.3 and footnote 4, in fact, does just that. And it does it in an excellent way in terms of defining what the monetary damage shall not be greater than, what should be offset against that damage, etc. So I do think that is an approach that is well within the grasp of the existing treaties if the states and both the host state and the capital exporting state takes action.
Sure. Dr. Piracha, please.
Yes, thank you. So I would agree with that. There do exist standards. There is guidance in international law. The treaties are invariably providing for what the states desire. I think where an amendment or where a reform is actually required is with the conduct, and I know many of the financial experts are now going to disagree with me, but I think there is a need to regulate the conduct of the experts. Many of these experts appearing as independent experts are actually people who are arguing on behalf of the party. And there have been instances where tribunals have openly criticized conduct of the financial experts like Navigant. One of the cases that I did in a commercial arbitration, we had names like Ernst & Young arguing that the valuation of the claims was less than $60,000. And we were claiming $6 million, and we eventually won on that argument. Should there not be repercussions for big names like those who argue just to make that argument in favor of a party? There, I feel, should be maybe to cater for the discrepancy in the level of the expertise of these experts that some of the more affluent companies bring as opposed to the developing countries. Maybe there should be just one expert appointed by the tribunal or the center who is actually independent. And when you read the Tatian Award, that's a 1,000-page award, I think it is astounding the number of times the tribunal highlights that the financial expert appearing for Pakistan had failed to address something that was critical. And even during the transcript and during the hearing, the expert failed to answer many of the critical questions. So maybe if there was just one expert appointed by the tribunal or the center, that might not only reduce the costs, but overcome the issue of the discrepancy in the financial experts that appear from both sides.
Sure, interesting. So, here I would, like to end this discussion and leave a thought for everyone who's listening and to ponder upon, and especially the arbitrators is that while let's say we apply the DCF, I mean the various thoughts that we've heard today, let's say we apply DCF, but is there anything that binds the tribunal to not go with the DCF discounting part? What I mean is, leave aside the discounting and the claim, if it is stretched across 20-year or a 30-year or a 50-year period, that what it does is the award would say the state you need to pay the investor, but you can do that in a staggered manner. What it will help is, and why it will help is not pinching the pockets of the states right now as a claim. It is something that it's just a commercial thought that I wanted to leave everyone with. So with that, I would end this session, and with a great thanks to all of you to be on the panel today and sharing your insights. Wonderful to have you all. Thank you so much for this.
Thank you.
Thank you.
Thank you.